The law of self-defense content you are about to enjoy is presented for general educational purposes only. It does not constitute legal advice. If you are in need of legal advice, consult competent legal counsel in the relevant jurisdiction. Hey, everybody, come on in. Welcome to the Law of Self-Defense News and Q&A show for December 3rd, December 3rd, 2020. Come on in, folks. Come on in. Make yourselves comfortable. Get settled in. Those of you who are on Facebook, watching this on Facebook Live, I'd appreciate it if you could click that like, thumbs up button, that share arrow. Leave a comment with your city and state. All of this encourages Facebook to share the program more broadly, which, of course, they're disinclined to do on their own initiative. So I ask for your help in doing that. Also, as always, if you could let friends and family know about the show. This is our one show we do each week that is free, open access for folks who don't have to be a law of self-defense member to enjoy this content. It's our effort to kind of grow the law of self-defense community by letting folks develop a sense for what we do and how we do it over at Law of Self-Defense. Of course, I am attorney Andrew Branca. Thank you very much. That's always appreciated. Wow. So much applause. And I'm an attorney who specializes exclusively in use of force law, meaning defense of yourself, defense of others, and defense of people, and have for more than 25 years, I think, at this point. That's what we do at Law of Self-Defense. Now, part of our work, of course, is a normal law practice, but a large part of what we do is also educational, to put people in a position to be informed about the law of self-defense so they can make better informed, more confident, more decisive decisions in self-defense, knowing that they're well within the legal boundaries. And what we teach people is the actual law. So the law of self-defense based on actual statutes, jury instructions, court decisions, not internet myth, what your cop buddy down the street told you, what the lawyer who did your house closing might have told you, the actual law of self-defense. And the value we try to add is to translate all the legalese into plain English so it's actionable information for you, because the more actionable and understandable it is, the more able you are to act decisively in defense of yourself and your family without having to try to figure out the legal hoops when you're actually facing a life-threatening attack. So, again, this is our weekly news and Q&A show. We do this generally every Thursday. We skipped last Thursday, of course, because it was Thanksgiving, but I encourage you to mark your calendars. Every Thursday, 4 p.m. Eastern Time, we do the show live on Facebook, our Facebook page, facebook.com/law of self-defense. And for our members, we also encourage members to enjoy the show through their member dashboard, which they can get at lawselfdefense.com, our website. Now, if you can't make the live show, we do make a recorded playback available, both to our members on their dashboard and here on Facebook, and also on our YouTube channel, youtube.com/law of self-defense. And of course, exclusively for Law of Self-Defense members, they can also get this content, like all our content, as a podcast. So we have a members only Law of Self-Defense podcast for those of you who enjoy podcasts. I know I certainly do myself. So let's see what we have lined up for today. Before we jump into the substance, I do, of course, have to mention our sponsor, which is CCW Safe, a provider of legal service memberships, what many people mistakenly call self-defense insurance. In effect, CCW Safe promises to pay their members' legal expenses if the member is involved in a use of force event, and those expenses start big and get bigger fast, folks. Imagine a scenario where you're threatened, you display your gun, you don't fire the gun, you don't hurt anybody, but you end up charged with aggravated assault with a firearm, which in most states is good for 10 years in prison, many states 20 years in prison. And if you are charged with aggravated assault with a firearm, you'll be paying your lawyer, your lead counsel, a retainer on the order of $30,000 to $50,000, folks. And that's for pretrial work. That's not for going to trial. If it's a case where you've actually had to shoot someone and kill them in self-defense, and you're charged now with a killing charge like manslaughter or murder, you're looking at $100,000 to $200,000 in legal expenses pre-trial, before you even get to trial. So unless you have that kind of money stuffed in a mattress, just in case you're compelled to defend yourself or your family, it can be helpful to have a financial partner standing behind you to pay for the legal defense the way you'd want that battle fought, which is really as if your life depends on it, because it does. And that's what CCW Safe does for its members. Now, as you might imagine, there are other companies that offer similar services. I've looked at all of them. I found that CCW Safe is the best fit for me. I'm personally a member. My wife, Emily, is personally a member. Frankly, one of the reasons I preferred it over others is that many of those others offering what they claim are similar services place a cap on how much they'll pay for your criminal legal defense. And that cap may sound like a lot of money. One of the main competitors has a cap of ranging from $150,000 to $250,000, and that's certainly a lot of money. But if you've killed someone in self-defense and find yourself charged with manslaughter or murder, you'll burn through that before you even get to trial, folks. So be very careful. CCW Safe does not have that kind of cap. They'll pay what the defense costs, period, including for appeals, by the way, if you are unfortunately convicted. So whatever one of these services you're considering, pay attention to what you're actually paying for, folks. If there's a cap, even if it sounds like a lot of money, it's probably not enough for an adequate legal defense. Now, having said CCW Safe is the best fit for me, whether they're the best fit for you is something only you can decide, but I do encourage you to take a look at what they have to offer at lawofselfdefense.com/CCW Safe. And if you do decide to become a member of CCW Safe, you can get 10% off your membership at that URL, lawofselfdefense.com/CCW Safe, using the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10. Okay, so let's look at what we have lined up for today's news and Q&A show. First, a couple news items. One involves the George Floyd case, the 4 officers charged with various felonies, killing felonies and others, in the in-custody death of George Floyd. And the prosecutor in that case is the Attorney General of Minnesota, Keith Ellison, and he is demanding that the trial court not allow cameras in the courtroom during the trial. Now, Minnesota is one of those states that normally doesn't allow cameras in the courtroom. This trial judge has announced that he will allow them, which is contrary to the standard practice in Minnesota. He says he's allowing them largely because of public interest in the case. The Attorney General doesn't want cameras. Folks, if the prosecutor does not want cameras in the courtroom, it's not because he has an awesome case, okay? It's because he's worried about his case. And unless there's cameras in the courtroom, we won't really know what happened in that trial. I can tell you, many of you probably first learned of me. I first came to your attention during the George Zimmerman case down in Florida, 2012, 2013 time period. And Florida is one of the states that generally does allow cameras, had cameras in that case. So the entire world could watch every minute of that trial, just like I watched every minute of that trial. And I can tell you, it was shocking. Every day, I expected the prosecution to show us, show the world, show the court the evidence they had that Zimmerman had engaged in criminal conduct, had acted with malice, was a racist, all these things that had been alleged for months, 14 months before the trial. And every day they never did. And the only reason I knew they never did was because I was able to watch every minute of the trial. Without the cameras in the courtroom, we're stuck with really news reports, media reports of what's going on. And unfortunately, my apologies to any of you who are journalists, but unfortunately, generally journalists who cover these cases are idiots. They don't understand what they're covering. Even if they might understand what they're covering, they're generally already tied into whatever the consensus approved narrative is that they're supposed to be pushing. Anyone who reads news reports of the Zimmerman trial is going to conclude that a travesty of justice occurred in that case. And I get that reaction even from senior level federal law enforcement, local law enforcement, people who the only thing they actually know about the case is what they heard in the media. And if I only knew what I heard in the media, I would think that case was a travesty of justice too, because the media does not reflect what actually happens in the courtroom. Having seen what actually happened in the courtroom, I know that the real travesty there was that Zimmerman was ever brought to trial in the first place. It was ridiculous. It was the cleanest case of self-defense I've ever seen brought to trial. The reason I know that is because cameras were in the courtroom. So now the prosecutor in the George Floyd case does not want cameras in the courtroom. I suspect it's not because he believes that he has a compelling case that's going to be easy to prove beyond a reasonable doubt against these officers. Another story, just a local story that came up in the news, but folks, this is the kind of poor judgment that I hope to protect all of you from in the law of self-defense community, whether you're a law of self-defense member or not. And basically the headline of the news story is, and it's from Georgia, white woman arrested after pointing gun at two black boys riding their bikes. And the way the news story describes this is there's two black boys, as they say, 12 and 13 years old, riding their bikes. And they're near this woman's property, the news report says, not on the property, it says near the property. Of course, again, journalists get a lot wrong. And the news report says this woman was approaching her own property in her car, paused her car at her property line, and pointed a gun at these two boys. Didn't fire a shot. Nobody was injured. Who knows why? Perhaps she thought they had some malicious motive in mind, that they were there to steal. I have no idea. Can't engage in mind reading. She thought there was some apparently reason for her to be pointing a gun at these two children, really, 12 and 13 years old. And now, of course, she's been charged with aggravated assault with a weapon. Now, the relevant statute here is Georgia Statute 16-5-21. If you'd like to read the statute, you can find it at lawofselfdefense.com/16521. You want to grab a pencil and write that down. It's lawofselfdefense.com/16521. But the relevant part of the statute reads, a person commits the offense of aggravated assault when she assaults with a deadly weapon, and assault in this context means putting someone in fear of imminent unlawful harm. When they assault with a deadly weapon, which of course she did here. So she put this 12 and 13-year-old in imminent fear of, the prosecution's claiming, unlawful harm using a deadly weapon. And frankly, unless she has a really good explanation, and she might, again, news reports only tell you one side of the story, so we don't really know her side of the story, but unless she has a good explanation, folks, the penalty for aggravated assault with a weapon, a deadly weapon in Georgia, is up to 20 years in prison. So she's looking forward to spending much of the rest of her life in prison if she gets convicted. Now, again, it's just a news report, so it's hard to tell what's actually going on. We haven't heard her side of the story, but the basic facts certainly tie into the common narrative that's being pushed now, basically, if a racist white person threatens black children with gun for no good reason. I can tell you today, there's no law enforcement agency or prosecutor in the world that's going to let this go as mere bad judgment. I mean, maybe 20 years ago, given that no shots were fired, nobody was hurt, they might have thought, well, she's just an idiot, and if she apologizes, maybe we won't prosecute her. But today, that's not happening, folks. Not on these facts. She's going to a very expensive trial, and she may well get convicted. And if she's convicted, the judge may well sentence her to the max, 20 years in prison. So please, there are circumstances in which it's prudent and appropriate to risk 20 years in prison. But this doesn't sound like one of those scenarios. Another item in the news, the Rittenhouse attorney. So John Pierce is one of Kyle Rittenhouse's attorneys. Rittenhouse, of course, is being prosecuted in Wisconsin, as we all know. And there's a news report here that the court in Wisconsin has accepted that John Pierce can be on the legal team as an attorney in Wisconsin. And the headline here makes a big deal out of the fact that John Pierce is not licensed to practice law in Wisconsin, as if that's shocking, or that means that him being permitted to be in the courtroom as part of the legal team as an attorney is unusual. Folks, this is not unusual at all. Normally, the default, of course, is if you want to practice law in a state, in a general way, you have to be admitted to the bar. But it's very common for outside attorneys, especially high-profile attorneys, to come into high-profile cases in states in which they're not admitted to the bar, but to present themselves to the court, file a request to allow themselves to be part of the legal team. Basically, the judge will ask them a few questions, and if they're demonstrably competent, and very important, there's other lead counsel. So there's local lead counsel on the case as well, an actual Wisconsin attorney on the case. They're permitted to help practice law as part of the legal team. Very, very common. So nothing unusual about this at all. And by the way, John Pierce has exemplary credentials as a prosecutor. In full disclosure, I should mention I did talk with John a couple weeks ago about the case. Naturally, I can't share any details of that discussion except to say that I am not part of the legal team or associated with the case, at least at this point in time. But he certainly struck me as extremely competent and capable. And I think Kyle is better off to have him on the case than not. Okay, let me see if anyone's brought up any news story questions before I jump into the questions that were sent in ahead of time. Facebook looks pretty clear. And so does the Law of Self-Defense membership dashboard. All right, so let me jump into the questions. Now, the first couple questions I want to knock out pretty quick because they have a heavy emphasis on gun law. And folks, I say this a lot, and I'm going to say it again as often as necessary. Our focus here is on use of force law, not gun law. And they're really two different things. Use of force law, when are you permitted or not permitted to use force in defense of yourself, others, property? That's what we cover here. And use of force law is fairly consistent across the 50 states, about 80% the same across the 50 states, which is why we can maintain a high degree of expertise on the use of force law of all 50 states. Of course, they all have their own statutes and jury instructions and court decisions, but the underlying legal principles are largely the same. The biggest variance is whether or not there's a duty to retreat, and there's lots of other little tweaks. Especially when you get to the defense of property, there's a lot more variability there. But at least in terms of defense of persons, it's pretty consistent across the states. We don't do gun law. Gun law being what kind of guns are you allowed to own? Where can you carry them? What licenses do you need? What's not permitted? Either on a state or federal law. So I've been a gun owner all my life. I carry a gun for personal protection. I've been licensed to do that in more states than I can remember all my adult life. I know as much about gun law as I need to know as a gun owner, maybe a bit more than usual, but I don't claim any particular degree of legal expertise. And frankly, I think it would really be almost impossible to claim 50 state expertise in gun law just because of the high degree of variance in gun law across the 50 states and even within states. In some states, the gun law is not even consistent across the state. It can vary from county to county, from city to city, urban to rural. It's simply madness. There is a very slight area where gun law can impact use of force law, and I'll touch upon that in just a moment. Also, as a general rule, I try not to dive deep into state-specific law, even state-specific use of force law, if I can avoid it, because we have people who listen to this podcast, both live and in recorded playback, from all 50 states, folks, really from all over the world, believe it or not, although I don't understand why people outside the United States listen to the show. They're certainly welcome, but I don't know anything about use of force law outside the United States. But we have people from all 50 states, and if I get into state-specific law that's unusual in any degree, it's only useful to a tiny percentage of the audience. So I can't really do that for the most part. Now, there are, of course, things I know off the top of my head that are state-specific, and I'm always happy to share those with you. But generally, we have to speak to these issues in a general way. So that out of the way, we had a couple questions that were emailed in. One is from Tom, and he asks, what are the consequences of illegally concealed carry in an establishment with the no concealed weapon sign on the door? So carrying concealed in a posted property. And he specifies South Carolina, but again, I'm not going to get into the details of South Carolina gun law. I don't know anything about South Carolina gun law, but I can speak generally about the possible impacts of carrying in a posted facility, a banned facility, no guns facility, as it might impact self-defense. And we have a related question from Kim, also emailed in, and she's basically asking about these the arm brace, shoulder stock issue. She says, I'm worried that law enforcement will not understand that these are pistols, legally pistols, these small ARs with the arm brace on, and they will arrest you for having a short-barreled rifle. Obviously, you could convince them, meaning me, I could convince them, get them out of jail. But what documentation would you keep with a firearm to avoid arrest? So to the extent that these are gun law questions, I can't answer them. And by the way, Kim, I don't think anybody knows what the law is right now in terms of AR pistols with arm braces on them. I'm not sure ATF knows. So it's madness. I don't think anybody knows what's lawful or not lawful in that context. But let me address both Tom's and Kim's issues generally. And that is, how can arguably, potentially, being engaged in some unlawful activity impact your claim of self-defense if, while you're doing that, you're obliged to use force in defense of yourself or others? And the answer is, for the most part, it doesn't. For the most part, the gun law issue and the use of force law issue are distinct from each other. So for the most part, you might well be guilty of some gun law violation. So in some states, if it's posted no guns and you carry there, it's a criminal offense. You could be on the hook for that. That doesn't necessarily have anything to do with a claim of self-defense should you be compelled to use force in defense of yourself or others. You might have that AR with the arm brace, and who knows? Nobody knows, I don't think, today if it's lawful or not. But let's say they decide after the fact that, it turns out it was unlawful. Well, you may have committed some kind of federal felony, I don't know, in the gun law sense, but it shouldn't have any impact on your use of force conduct. Now, there are a small minority of states that do condition self-defense generally on not being engaged in unlawful activity. And in those handful of states, you could jeopardize your claim of self-defense if you're engaged in unlawful activity. And that might not even require that a posted building carry criminal penalty, that it's actually a crime. Because if it's posted and it's private property and you nevertheless carry your gun on that property, even if it's just the carrying itself is not a crime, I'd argue you're committing a trespass on that property. You're only allowed to be on someone else's property with permission if you meet their conditions for being there. If you're violating their conditions, well, you're not there with license anymore. So I would argue that's a trespass in and of itself. And if the state you're in, the jurisdiction you're in, conditions self-defense generally and not being engaged in unlawful conduct, the prosecutor might argue, well, that's a trespass. That's unlawful conduct. With the arm brace thing, I think we just don't know whether it's unlawful or not. But again, if it is determined to be unlawful, well, if you're in one of those states that conditions self-defense generally and not being engaged in unlawful conduct, you could find yourself in trouble on your self-defense claim. Now, more broadly, most states do not condition self-defense on not being engaged in some unlawful conduct generally. But there are facets of self-defense that can nevertheless be implicated. So it's very common. There's about 36 states that are effectively stand your ground states, either by statute, they have a stand your ground statute, about half of them, or by court decision. Like California is a stand your ground state, not by statute. California has no stand your ground statute, but by court decisions going back to the 1800s that are still perfectly valid law. California is, in fact, a very robust stand your ground state. The states that are stand your ground by court decision, basically it's a blanket stand your ground. So you don't have a legal duty to retreat before you can otherwise lawfully defend yourself, period. That's it. Very simple. In those states, if you were, say, carrying a gun unlawfully in a posted property, you wouldn't lose that stand your ground privilege because you were arguably engaged in some unlawful activity. But in the other half of the stand your ground states, the ones that are stand your ground by statute, often those statutes have conditions that have to be met to qualify for stand your ground. One of those conditions very commonly is that you're not otherwise engaged in unlawful activity. So in those states, and there's 17, 18 of those states, you carry the gun onto the posted property. You may not lose self-defense generally, but you might lose your stand your ground privilege, your statutory stand your ground privilege, and have effectively reacquired a legal duty to retreat before you can otherwise lawfully defend yourself. And what that does from a legal perspective is it opens up another avenue of attack for a prosecutor on your claim of self-defense. Before, if you were not acting unlawfully, the prosecutor couldn't really attack your claim of self-defense because of a failure to retreat. But when you carried the gun on the property contrary to the posting and were arguably trespassing, now the prosecutor is going to argue, well, if you'd been acting lawfully, you wouldn't have had a duty to retreat, but you weren't acting lawfully. You were trespassing. Therefore, you did have a legal duty to retreat. I think you didn't when you could have. That's what I'm going to argue to the jury. That's how I'm going to attack your claim of self-defense. So that's how being engaged in unlawful activity can impact a claim of self-defense. In a few states, they can attack self-defense generally because you need to not have been engaged in unlawful activity generally in order to qualify for self-defense. In many other states, they can attack specific facets of self-defense, like your stand your ground privilege, if you were arguably engaged in unlawful activity. Another quick question comes in from Boris from New Jersey, really a gun law question. And folks, I don't really do gun law. It's a Second Amendment question. Folks, I consider myself a Second Amendment absolutist. I think all gun laws, preemptively applied to law-abiding, mentally sound American citizens are facially unconstitutional. But obviously, there's many states and jurisdictions that don't agree. One of those is New Jersey. And Boris asked, there's a lot of Second Amendment lawsuits taking place in New Jersey from the NRA, Second Amendment Foundation, life members in both of those, by the way. He names a couple of other groups here. And what are the prospects that they may win? Basically compel New Jersey to become a shall issue state, as opposed to, technically, I guess it's may issue, but effectively it's no issue. And the answer to the question, folks, is not really a political answer. These are not political questions. I'm sorry, not really a legal answer. These are not really legal questions. These are political questions. These are questions, the answers to which are determined by who has more members on their team in the fight. So I read many of these Second Amendment decisions, and the ones that are pro-gun control strike me as verbal, cognitive word salad. They're nonsense. They're ridiculous. The standards they apply to the Second Amendment, like the failure to apply strict scrutiny to laws that constrain the Second Amendment, they would never apply to any other fundamental constitutional right. I mean, there's no legal reasoning happening here. They are on a gun control political team. So if you're in front of a court that's anti-gun, you're going to get an anti-gun decision. If it's a court of appeals with 3 judges on it and 2 of them are anti-gun, you're going to get an anti-gun decision. It's got nothing to do with the legal merits of the case. It has to do with the political team that they're on. If you want to win these fights, have more members of your team in the fight. Goes to a court of appeals and there's 2 out of 3 judges that are pro-gun, you're going to get a pro-gun decision. That's how these work. Now, hopefully we'll see more favorable decisions for gun owners for the Second Amendment, given the judges that Trump has put on the federal bench, obviously only the federal bench in his first term. But we'll have to see how that washes out. But it's not a legal question. It's a political question. Okay, now here's a good one. So Anthony is one of our Platinum members. So he used the Platinum member Q&A form to submit his question. And he asks, are you aware of the video, Don't Talk to the Police? Any comments with respect to self-defense? And probably most of you have seen this video. It's on YouTube. It has well over 1 million views. It's basically a video put together of by a law professor, James Duane, I think at the time, I don't know if he's still there, Regent University Law School. And near as I can tell, Professor James Duane is excellent professor, excellent attorney. He got his law degree from Harvard Law School. And he does this rather lengthy video encouraging people to never talk to the police. In fact, he literally says, never talk to any police officer under any circumstances. And if you're interested, just Google Don't Talk to the Police or Never Talk to the Police, and I'm sure it'll pop right up on Google. And of course, this is a video I've been asked questions about for years. And in fact, I did what I call a debunking of this video in considerable detail way back in 2017 on my own YouTube channel, back in the day. Frankly, I think that Professor Duane's advice is relevant under many circumstances, but is not particularly appropriate to the self-defense context. I'll give some examples of that. Now, my video is no longer available on YouTube, my debunking. We've locked it down on YouTube. But for those of you who are law self-defense members, I have retrieved our 2017 copy, and we're making it available to you as blog posts. Now, it's about an hour long, my debunking, so it's too long really for one blog post. So we broke it up into 2 parts, part 1 and part 2. They're dated December 4th and 5th, meaning tomorrow and the next day, but in fact, we've already loaded them up. So you can get my part 1 debunking of Never Talk to the Police is already up on our website for our law self-defense members. It's about half an hour long, and tomorrow morning we'll post up part 2. Again, that's law of self-defense members only content. So you would need to be a member to grab that context. But in my debunking, I'll touch on a few of the concerns I have with Professor Duane's approach. First of all, this admonition to never talk to any police officer under any circumstances. So what if you're involved in a self-defense event? You're walking through a parking lot. You're attacked by somebody with a machete. You draw your pistol. You shoot them. What do you do now? Do you just go home? Do you call 911? Because guess what, folks? If you call 911, guess who you're talking to? You're talking to the police, right? Or do you not call 911? But if you don't call 911, you just leave the scene. Are you fleeing the scene for purposes other than safety to escape accountability? Keep in mind, self-defense is a defense of confession and avoidance. If you want to qualify for self-defense, you don't deny that you committed the underlying act. You don't say, oh, it wasn't me who shot him. You say the opposite of that. You say, it was me who shot him, but I shot him with the legal justification of self-defense. You confess not to a crime literally, but to the underlying physical act, but you seek to avoid criminal repercussions because you claim your conduct was legally justified. If you deny you did it, you can't claim self-defense. I mean, you can't say, I didn't shoot him, but if I did shoot him, it was self-defense. I mean, that's not coherent. So when he says never talk to any police officer under any circumstances, I'm not sure how he expects that to apply in a self-defense context. Now, and I want to be very fair about that. I don't think when he made his video, he was thinking specifically about the self-defense context. In fact, my recollection is none of the examples or hypotheticals he uses are self-defense hypotheticals. They're all different kinds of scenarios. And I have reached out to him and asked him specifically if he could clarify for me and for the law self-defense community how these things he says in the video would apply in a self-defense context. But unfortunately, he's never responded to my efforts to get in touch with him personally. So I'm not sure how he thinks about that. But in the context of self-defense scenarios, a lot of the arguments he makes in his video strike me as really inappropriate. Straw man arguments that don't apply in that context. So, for example, one of the arguments he makes is, well, if you give a lengthy, detailed explanation to police, say at the scene, that could get you in a lot of hot water because the details don't remain consistent. And he does this by like reading a lengthy letter to the audience and then asking them to repeat back details of the letter. And of course, they get all the details wrong. And it's true that in the aftermath of a use of force event, your brain does not capture, store, and recall information the same way it does normally. Your recollection is damaged. You'll remember things that didn't happen. You won't remember things that did happen. You'll get details wrong. So if you were to give a lengthy, detailed explanation to officers at the scene, there's going to be a lot of mistakes there. And those mistakes might be used to try to characterize you as trying to lie about what happened, mislead the authorities. But here's the thing. There's nobody responsible in the self-defense community who advocates giving a lengthy, detailed explanation to the police at the scene. Nobody does that. The two approaches most responsible trainers in the self-defense community advocate are either say nothing, at least after calling 911, just say, I just want to talk to my lawyer. That's one approach. Or a kind of modified say little approach, which is what we teach. We encourage people to consider. It's not appropriate for everybody, but do things like identify witnesses, identify evidence, state your name, state your location. I mean, really basic stuff, but more than nothing, which is what makes it different than the say nothing approach. But nobody says, give the responding officers a complete detailed debrief on what you think happened. So I think that argument he makes is really not relevant to a real world self-defense scenario, at least not among like any of you who, of course, you're members of the law self-defense community, you're educating yourselves. If somebody's really completely ignorant of any of these dynamics, just a blank piece of paper, well, yeah, they probably shouldn't be talking to the police. But in your context, I think it's a more subtle decision. And when we teach our full day class, we spend almost an hour talking about nothing but interacting with the police in the aftermath of a use of force event. So there's quite a lot of subtleties there. Another argument he makes that I find really odd is that, hey, sometimes when you tell the police A, they'll just make stuff up. They'll say you said B. They'll lie about what you said. Well, that can happen. I mean, I'm not sure it's a lie. I mean, maybe they misheard, or maybe, what you say goes in their ear, gets translated in their brain. Maybe their note taking was sloppy. Of course, maybe it was malicious, right? Maybe they just make stuff up, like he argues they do, at least on occasion. But my response to that is, well, what are you going to do about that? I mean, if they're going to make stuff up, if you say A, they'll claim you said B. Well, if you say nothing, they'll claim you said B, right? I mean, if they're just going to make stuff up, if they're just going to lie, they're going to lie anyway. So I'm not sure how not saying anything solves that problem. He argues another reason not to talk to the police is that it won't stop you from being arrested. Well, okay, duh. Nothing's going to stop you from getting arrested. That's not up to you. That's up to the officer. If they want to arrest you, you will be arrested. The arrest might be meritorious or not. That's an issue that's argued later. And by the way, arrest is one of the least important things to worry about as far as I'm concerned, especially if you've been involved in a deadly force use of force event. My concern is that you don't end up spending the rest of your life in prison. This woman in Georgia, through what appears to be bad judgment, aggravated assault with a weapon charge, is looking at 20 years in prison. That's what I worry about. The fact that you might have got arrested and been held over the weekend and had an arraignment and had to get bail and got out. If we have a strong legal argument and can keep you out of prison, that arrest is going to be a funny story you tell later. It's no big deal. It's the felony conviction that's the big deal. So I couldn't care less about the making of an arrest or attempts to avoid. Don't even attempt to avoid an arrest. It's not even worth thinking about. And there's a bunch of others. So I probably stepped through 15 or 20 of his arguments that he makes in his video in my debunking, and I explain why I think they're either wrong or out of context or don't apply to a real-world self-defense type of scenario. So I think generally his video does not. Now, I will say, if you're actually a criminal, if you're engaged in criminal conduct, if you're stealing stuff, well, for God's sakes, don't talk to the police if you're a criminal. Nothing good is going to happen to you from talking to the police if you're actually a criminal. But again, I think that's one of the things that distinguishes his advice as a general statement in general scenarios, legal scenarios on the one hand, and self-defense scenarios by otherwise law-abiding people on the other hand. So again, you can find that. We'll have part one up. Part one's up right now. Actually, if you're a law self-defense member, we'll have part two up tomorrow morning. Okay, so let me take that down. And by the way, folks, most of our content like this is members only. So for example, earlier this week, we came across a very interesting Colorado Supreme Court decision that was very recent, November 23rd. It was handed down. And it's an example of a state Supreme Court really mangling very simple concepts of use of force law. In this case, doctrines of the initial aggressor, provocation with intent, mutual combat, various ways of losing the element of innocence and thereby losing self-defense. And it's something to be aware of, folks. Even legal professionals at the level of state Supreme Courts often don't understand how to apply these legal concepts and legal doctrines. And by the way, folks, when I say things like this is a way to lose the element of innocence and lose self-defense, if you don't know what I mean by innocence, any claim of self-defense is made up of up to 5 distinct legal elements. They're no big secret. I'll share them with you right now. They are innocence, imminence, proportionality, avoidance, and reasonableness. If none of that makes sense to you, if you don't understand those 5 elements or what I just said, at the very least, I would urge you, please download our free infographic on this. It doesn't cost a penny. It's just a PDF download. You can get it at lawofselfdefense.com/elements. It lists those 5 elements, provides a brief description of them, because these are the building blocks of any claim of self-defense. And as the phrase suggests, all the required elements are required. They're cumulative. If any one of them is missing, well, you don't have a claim of self-defense. You don't have any legal justification for your use of force. That's not a good position to be in. Then you're in the apparent position of this woman in Georgia looking at 20 years in prison. So this infographic, if you don't understand this, you can't understand anything about self-defense law, please do yourself a favor. Download the PDF. It doesn't cost a penny. lawofselfdefense.com/elements. Okay, so let me get to the next question. This is from another one of our Platinum members, Lorraine. She says her question is in regards to the element of avoidance. So innocence is one element, avoidance is another element. And as I mentioned earlier with stand your ground, most states are stand your ground states. They don't impose, under normal circumstances, any legal duty to retreat before you can otherwise lawfully defend yourself. But about 14 states are duty to retreat states, and they do impose a legal duty to retreat if safely possible before you're privileged to use at least deadly force in defense of yourself. So those duty to retreat states do apply that element of avoidance. She says on page 135 of your book, well, thank you very much for the pitch. You suggest avoidance if you can get safely away and call police. And I do suggest that, folks, even if you're in a stand your ground state, if you can safely not have to fight, that's a great way to win a fight, folks. Don't be getting into fights you don't need to be getting into. If you can safely avoid the need to get into a physical confrontation, consistent with safety, please take advantage of that opportunity. But Lorraine's real question is, well, what about the current environment, these movements to defund the police, the subsequent potential for longer response times by the police due to budget cuts, manpower cuts? It can contribute to a feeling of unavoidability in a confrontation, knowing there may be a slower response time from police. Criminals may be emboldened. Victims may feel a greater sense of risk. Can a defense successfully argue the reasonable belief in the unreliability or a lack of confidence that a call to the police will result in a timely response? Well, it's a great question, Lorraine, and there's a lot of levels to this question. One is never assume you're going to get a response. Always assume nobody is coming. Nobody is coming to save you. I mean, they might, but you're willing to risk your life on that? And really, it's a separate question from avoidance, from escape, because safe escape assumes you can escape, well, with safety, to achieve a position of safety. Until you've achieved the position of safety, you haven't escaped anything. If you're trying to escape and the criminal's still pursuing you, you haven't escaped. You're still under imminent threat. So really, it's a different issue than legal duty to retreat. And it's really separate from police response time. I mean, police response time shouldn't be part of your tactical decision-making in self-defense. You have no idea when the police might or might not show up. There's no way for you to have any idea. They might be there in 5 minutes. They might be there in 50 minutes. You might live in a rural area where there's basically one deputy on duty for the county. You might get there in a couple hours. So there's no way to know when anybody's going to show up. Now, certainly that situation does not get any better with the police being defunded and police getting prosecuted for murders where they've done nothing wrong. And basically, the Ferguson effect, they stop responding to most calls. We're going to see a lot of that because police are human beings and they're going to respond to these policies as normal human beings would respond to these policies. They don't want to go to prison for the rest of their lives for doing their jobs either. So certainly I don't expect police times to get any better moving forward, but it really shouldn't be part of your tactical decision-making, and it can't really be part of your legal decision-making because you don't know when they might or might not show up. Now, let's imagine you could know. Let's imagine that you knew somehow that police response times in your town had tripled from 10 minutes to 30 minutes or 20 minutes to an hour or whatever. There was a news report. Some journalist had miraculously developed a brain and decided to actually investigate police response times, and there were records they could look at. So there's a way to document that the response time has tripled. And now maybe you didn't know it at the time. Maybe you hadn't looked at that data or read the news report. Maybe you did. But you're involved in a use of force event and you ended up using force. And one of the foundations for why you claim your use of defensive force was reasonable was this lengthened response time. Would that lengthened response time be admissible evidence in court to buttress your justification, the reasonableness of your use of force? The answer is, of course, being a lawyer, is maybe or maybe not, but really mostly maybe not. For one thing, it's the kind of knowledge we would call specialized knowledge. Normal people wouldn't possess this knowledge. It's not like fire is hot, ice is cold. You would only expect someone to know about this change in response time through basically specialized knowledge or training or experience. So it's not by default admissible in evidence. You would have to, if it's one of the factors that drove the reasonableness of your decision, for one thing, you would have to be able to demonstrate that you possessed that knowledge at the time you made the decision. So if you made the decision to use force, and then while you were sitting in jail awaiting trial, you read a news report later about the response time tripling, well, if you didn't know it at the time you used the force, it could not have influenced your decision-making at the time you used force. So it can have impacted the reasonableness of your decision to use force because you didn't know it at the time. So that would not be admissible for that purpose for sure. What if you did know it at the time? Well, now you have to be able to document that you knew it at the time. Can you do that? Or did you just read a news report and there is no documentation that you possess that knowledge? It's only your word. Now, even if it's only your word, if you're willing to take the witness stand, you may be able to talk about the fact, hey, I read this newspaper article. That might be okay. But then you're taking the risk of taking the witness stand and subjecting yourself to impeachment and cross-examination. And there's a reason most criminal defense attorneys don't put their clients on the witness stand. What if you don't want to take the witness stand? Is there any other documentation that you possess this knowledge? And if there isn't, the chances of it being admissible is close to zero. Now, a good example of this kind of thing was the Theodore Wafer case in Detroit a few years back. Theodore Wafer was asleep in his Barca lounger in his house in Detroit, high crime area, heard a very loud pounding on his front door, thought he heard pounding from the back door, thought his home was about to be invaded. Apparently, there were a lot of home invasions in this community. He retrieved his Mossberg pistol grip shotgun, carefully approached his front door, opened up the front door crack to see what he could see, and a figure lunged sideways across the doorway, not into the house, but side to side by the doorway. And either deliberately or because he was startled, Wafer discharged the shotgun and shot a very drunk 20-year-old black woman through the head, killed her instantly. She was, in fact, no threat. She thought, we suspect, that she was thought she was at the house she was supposed to go to a party at and was angry they weren't letting her in. That's why she was pounding on the door at 0200 in the morning. And Theodore Wafer was charged with manslaughter, brought to trial. And one of the things he tried to introduce into evidence, his lawyer tried to introduce into evidence, was basically a crime map of his neighborhood. And it was a map of the blocks around his house, and it listed all the violent crimes, the home invasions, the armed robberies, the rapes, the murders that occurred. And this is Detroit, and there was a lot of those. So it's a big map, giant billboard rolled into the courtroom, lots of little pins on it indicating where all the crimes were. And it's pretty chilling, really. And of course, the reason they're trying to introduce this is they're trying to say, listen, my client knew he lived in a high crime neighborhood. These are all the crimes. I mean, he read about them in the paper. So that formed part of the reasonableness of his perception that he was likely facing a home invasion, a life-threatening attack, and so forth. Well, that crime map was not admitted into evidence. The judge wouldn't allow it. And the reason the judge wouldn't allow it was because they were not able to document that Theodore Wafer was actually aware of those specific crimes at the time he fired a shotgun into the girl's head. Now, he may occasionally have read about stuff in the paper, but he couldn't document, I knew about this crime on the map and that crime on the map and that home invasion and that armed robbery. And if he couldn't demonstrate that he possessed that knowledge at the time he fired the shotgun, they couldn't admit those facts into evidence in support of the reasonableness of his claim of self-defense. So very important reason generally, folks, to always document your training, of course. I hope that doesn't even need to be said. But also document any facts you think you might be relevant to your decision-making in self-defense. If you read in the paper, of course, who reads papers anymore, but on the internet, that response times have tripled in your community, that could potentially be relevant to a self-defense event. But if you think it might be, and you might want to use that as a basis for the reasonableness of your use of force decision, I would save that article. I would email it to yourself. I would do something to make sure. You don't need a lot of documentation, folks. I mean, you need really very little, but you need more than zero. So do something that's more than zero evidence that you acquired that knowledge prior to your use of force in self-defense. All right, another question from a Platinum member, and then I think we'll go to questions in from the live audience. So this comes in from, he gave me his name, but of course, unfortunately, it's a very distinctive name. So I don't want to use it because we really try to keep people anonymous unless they say otherwise. So, but he is from Florida, so I'll just say Florida man, one of our platinum members. And he asks a rather detailed, rather tactical question about, you have a 12-gauge shotgun for home defense. You have a variety of rounds, slugs, buck, rock salt, pepper rounds, OC rounds. I presume he means some kind of semi-non-lethal rounds, although I would suggest anything coming out of a shotgun is is pretty close to potentially lethal. But he says, imagine that. So you have a shotgun with basically deadly force rounds and non-deadly force rounds. So you hear a bad guy, I guess, outside your home, check to see, lights on, you confirm he's a bad guy coming at you. All right, it's a big presumption. You've identified that you're in fear for your life. Okay, well, you need to be in reasonable fear. So there has to be a factual basis for why that is. He's coming at you with intent to kill. Well, again, there has to be a reasonable basis for inferring that he has an intent to kill. There may be, right? He's got a knife, he's got a weapon, he's not stopping when you order him to stop. But you need something. You can't just mind read. That's not admissible in court. Oh, and then he adds, and he's made a forceful entry, presumably into your home. Well, that pretty much settles the issue, especially in Florida, folks, because in Florida, like many states, has a home defense statute that creates a legal presumption that you have a reasonable fear of an imminent deadly force harm if the person you're defending yourself is unlawfully and forcibly entering your home or attempting to unlawfully and forcibly enter your home. If you're interested in that, reading that statute, and it's not universal across 50 states. Not all states have this kind of legal presumption of reasonable fear, but in states that have it, their statutes tend to pretty much model the Florida statute. The relevant statute in Florida is 776.013. It's their home protection statute. If you'd like to read it, you want to grab a pencil, you can find it at lawofselfdefense.com/776013. No dot in there. The statute has a dot, but I don't use it. lawofselfdefense.com lawofselfdefense.com/776013. So once you add to the hypothetical that the person is forcibly entering your home, presumably also unlawfully, then he adds, and they have a knife, the law presumes that you're facing an imminent deadly force threat. I don't think there's any other interpretation at this point. Forcibly, unlawfully entering, they've got a knife. I don't know what the other interpretation of that would be. Then he asks, well, you have two options. Let's imagine you have two defensive options. One is fire a shot of rock salt to bring him down. I guess the presumption is supposed to be in a non-deadly force manner. I would suggest that rock salt is not non-deadly force. Deadly force includes force readily capable of causing death or serious bodily harm. I think if you put a load of 12-gauge rock salt into someone, you've caused them great bodily harm. But let's imagine we're talking two options. A non-deadly force shotgun option. Let's imagine it's a beanbag round, for example. Or option two would be deadly force, just a slug into the person entering your home. So clearly deadly force. So we have two options. This guy's forcibly, unlawfully entering your home with a knife, and you can either use the beanbag round or you can use the slug round. Folks, I would suggest we're asking the wrong question, and we're getting too wound up in the tactical details, okay? I urge you to stay practical. Keep things simple. Don't put yourself in a position where you have too many choices to make, and the choices you make need to be practical choices. The more difficult choices you have available, the slower your decision-making is, and the more likely it is you are to make a bad decision. We see this very commonly when we run students through our self-defense simulator program, the video simulator program. You just give them the IR pistol, and people, if that's their only defensive tool, well, they perform at a certain level. The moment we give them the infrared, the fake OC Can 2, so they have the pistol in one hand, the pepper spray in the other hand, oh my gosh, the decision-making, I mean, the speed and correctness of decision-making drops like a stone, just because now they suddenly have a second choice to consider. I'm not saying don't have a second choice. I always encourage people to, if you carry a gun, I urge you to carry pepper spray. I certainly do, always. but of course, I've trained and thought through those options well beforehand, so I don't get tied up in that decision-making loop at the time. If you're facing someone who's breaking into your home with a knife and you've got a shotgun in your hand, I find it difficult to imagine you're seriously going to have two different rounds in the other hand, beanbag and slug, and make a decision in the moment which of those you're going to use. And the circumstances justify the use of the slug. So I would suggest a practical option. Now, assuming the imminent deadly force threat is there, right? The law will presume it's there. If you also believe it's there, why would you not use the deadly defensive force option? Why complicate that self-defense scenario? And by the way, if it's not a deadly force threat, if it's, who knows, some non-deadly force threat you're facing, for God's sakes, don't be using a shotgun. That's what things like pepper spray are for. So the real answer to that question is, I think, let's not get too wrapped up in the tactical details and options. Few of us are John Wick. We're not going to sweep that little side-mounted round off the side of the shotgun, drop it into the chamber, and suddenly have a different round at our disposal. I just don't think that's realistic. All right. Well, we actually got through all the real questions. So let me step through the questions or comments that have come in through the Law of Self-Defense membership dashboard. Thanks all you members, Law of Self-Defense members, for joining us. See many of the same names. Oscar's drinking from his Law of Self-Defense coffee mug. Me too, Oscar. By the way, if anyone's interested in one, Law of Self-Defense on one side, hard to kill, hard to convict on the other side, we do make these available at lawofselfdefense.com/mug. Let's see. Joe mentions for the shotgun scenario, your shotgun should already be loaded with your self-defense ammo. When the guy's in your house with a knife or trying to get in, you should not have an unloaded shotgun. Yeah, I think the same. You should not be making your round decisions in that moment. Those decisions should have been made already. All right, let's take a look at Facebook. Hey, Will. Good to see you, as always. Oscar is both on Facebook and the membership dashboard. Michael asks, what if somebody's a member of multiple programs? I only see complication there, folks, and these programs are not inexpensive, right? I think are they $30 a month, $50 a month? So if you're in several of them, it's money. No, of course, maybe the money doesn't mean that much. Maybe you've got plenty of money, so that's not an issue. But it also raises the risk that they'll point fingers at each other, like go to that one first. I mean, insurance companies often do this. I've not seen this in the legal service memberships in the self-defense arena. I've not seen that happen, but I've certainly seen it happen in traditional insurance, where each insurance company wants you to go to the other first, and then they'll settle up later if anything's left over. Frankly, quite a number of these offerings for quote-unquote self-defense insurance, I think, are pretty bad. So I don't know why you'd spend any money on them at all. So it would be a difficult choice. Kim asks, do the insurance programs like CCW Safe cover what you thought was justifiable brandishing if you are arrested? You thought you were in imminent danger of serious bodily harm or death. They certainly ought to, because it's a use of force event. Now, I can't speak for any organization, and I don't pretend to know all their policies and exclusions and conditions by heart. I'm very comfortable with CCW Safe, which is why I'm a member. But all these programs have their own conditions and exclusions and limitations of different sorts. So all I can tell you is whichever ones you might be interested in, make sure you read the fine print and it works for you. Now, even CCW Safe, for example, I think one of their exclusions is they don't want to cover domestic violence situations. Well, if your life circumstances are such that that's a real concern for you, the person you're most scared of is, an estranged spouse, well, maybe CCW Safe is not the right choice for you. That's why I say I can't affirmatively say they're absolutely the best fit for everybody out there, because they may not be. But for any of these programs, please, folks, I just urge you, read the fine print of their membership agreement. And anyone who won't make that available to you, what can I say? I certainly would not consider becoming a member of that organization when I don't even know what I'm paying for, because I don't know what the details are. Certainly, CCW Safe will provide that level of detail. USCCA also provides that level of detail. I can't recommend them for a number of reasons. I don't have time in this show to get into that, but if I've written about it before, you can point your browser to lawofselfdefense.com/USCCA. That'll explain one reason I can't. Another reason I can't is I think that their caps on coverage for criminal defense are too low. I think the highest level they cover is $250,000, which it's a lot of money, no question. But if you're charged with murder, it's not a lot of money. You'll go through that, almost all of that, maybe all of that pre-trial, and then they're done. They walk out the door. They're not covering you anymore. They don't have your back anymore. It's just not enough. And of course, we can't predict ahead of time whether our necessary act of self-defense will result in the other person's, the attacker's death, and therefore potentially a murder or manslaughter charge. We don't know that. All right, folks, we're right at the top of the hour, so I think I will begin to wrap things up. Let me just make sure if I have anything else I want to... Oh, I do have something else I want to mention. We recently put together a totally free mini course on self-defense law. I think it's a little under an hour long. Our normal Law Self-Defense Advanced course is a full day course, so it's 8 hours long. The mini course is only about an hour, but it'll give you a good overview of these legal doctrines that we talk about, these legal concepts. It doesn't cost a penny, folks. Totally free. Not sure how long we'll have it up, so if that's of interest, I would encourage you to grab it sooner than later. It's all online. You can access that at lawselfdefense.com/free course. One word, free course. Again, I'm not sure how long we'll have it up. Frankly, it's probably something we should be selling rather than making free. We debate that internally, but for the moment, it's available free. So if that's of interest, I encourage you to take advantage of that. lawselfdefense.com/free course. And finally, just a reminder to all of you, if you carry a gun, presumably that's so you're hard to kill. That's why I carry a gun. So I'm hard to kill. My family is hard to kill. Folks, if you carry a gun so you're hard to kill, you also owe it to yourself to make sure you know the law so that you're hard to convict. All right, folks, until next time, again, this show airs every Thursday, 4 p.m. Eastern Time, and mark your calendar so you never miss an episode. But until next time, I will say I am attorney Andrew Branca for Law Self-Defense. Stay safe.